this morning's docket. This is case number 111125 in the matter of Trey Meyer.
May it please the court, Kate Baird appears on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, may I reserve 2 minutes for rebuttal, please?
2 minutes to grant it.
Thank you. Justices, counsel, this original action is before the court this morning on 2 complaints. Both complaints came from clients, the clients notified our office of concerns that they had with their counsel, their respondent, a solo practitioner in Douglas County. The first complaint was referred to the attorney diversion program after the respondent acknowledged his misconduct. In the matter, the rules that were stipulated to were 1.3 and 1.4, diligence and communication. He entered into the diversion contract in March of 2012. A condition of that contract, of course, required that he not engage in further misconduct. 6 months into that diversion contract, our office received another complaint from another client reporting that she had paid the respondent to file a petition for divorce to assist her in seeking a divorce, and that the respondent had failed to file the petition. She disclosed that the respondent had in fact told her that the petition had been filed. A review of the evidence before the hearing panel suggested that that representation had been made several times by email and then by telephone. On the morning of September the 4th, respondent reported to this client that in fact the petition had been forwarded to Douglas County. The respondent, that resulted, I should back up, that new report resulted in the revocation of the attorney diversion contract. The review committee set both for hearing. The hearing panel considered this matter on November 5th. They found that the respondent had engaged in misconduct in multiple instances, both with regard to both clients. The respondent acknowledged some of the misconduct. There was one issue that was a primary issue as far as the Disciplinary Administrator's Office was concerned with regard to an allegation that the respondent had in fact engaged in dishonest conduct. That was disputed at the hearing. The hearing panel concluded, after considering all of the evidence presented, that the respondent had engaged in dishonest conduct by representing to his client, both by email, in the emails, that he had in fact filed this divorce petition when it had not been filed. They further found that in spite of the respondent's representations at the hearing that this petition had been mailed or deposited for mail, that the petition had in fact been hand-delivered by the respondent or someone on his behalf on the afternoon of September 4th, 4 hours after he advised his client that the petition had been filed. The hearing panel recommended a 6-month suspension. We certainly advocated to the panel or suggested to the panel that a loss of license was warranted in this case. I'm renewing that suggestion and recommendation to the court. I would suggest that the conduct in this case demonstrates a need for a loss of license. I also will renew the request that the court direct that this respondent undergo a 219 hearing before being allowed the privilege to resume his practice.
Could you help me with what you mean by loss of license? I first thought you were talking about disbarment, but now you're talking about a 219 hearing.
Limited. I'm sorry, I didn't mean to interrupt you.
No, I just want clarification on what your request is today.
A suspension.
Suspension?
Not a permanent loss of license.
For how long?
I'm recommending this 6 month, that the court adopt the 6-month recommendation made by the hearing panel. I'm also recommending that a 219 hearing be ordered. The respondent testified at some length at the panel hearing regarding a series of incidences that had occurred beginning in 2007 that he was becoming aware of having a significant impact personally and professionally. He indicated at the hearing panel that he had sought treatment over the past year and described what he characterized as an alcohol addiction. Nothing was presented to the hearing panel in terms of any written documents, any notes, any reports from any therapist, or diagnoses from a counselor, or he reported going to Stormont Vale in the weeks immediately preceding the hearing. No written documents or discharge summary were provided for the panel to consider to determine the extent of what treatment was being sought, what the diagnosis actually was, and whether or not the respondent was actually on the right path to make sure that whatever impact this alcohol addiction, as he described it, had on his professional, performing his professional responsibilities. Certainly at a 219 hearing, a panel could expect the respondent, and I would hope would expect the respondent to present documentation that a problem has been correctly identified, addressed, so that we can ensure that the public doesn't face the same issues that have been faced by these two clients. And I have nothing further unless there's a question of the court.
The way the hearing panel wrote this caused me a little concern. I'm talking about paragraph 56. Have we said this better in our orders where they're saying at the reinstatement hearing the respondent be required to provide written evidence that he's undergone a complete alcohol evaluation and has completed the recommendation for treatment? I mean, is that satisfactory language to you if it were to go into the order? I can't remember what we've said. To me, it seems a little vague, and I don't want it to go into a reinstatement hearing without people knowing what they're supposed to do or what they're supposed to look at.
It would be my recommendation, should the court order a 219 hearing, that they require this respondent to undergo a psychological evaluation.
Rather than alcohol?
Well, or both. I was concerned with the description of these series of events that were described by the respondent at the hearing that apparently or may have led to what he described as an alcohol addiction. I didn't have anything, nor did the panel, suggesting that came from an expert. So I don't know if his information or the information presented was based upon an expert saying you have an alcohol addiction. So it would be my recommendation that the respondent undergo a psychological evaluation, and in the event that identifies an addiction, then we go from there. Something to substantiate that this is an addiction that is contributing to the conduct that's brought him here today.
Just as I'm making this up, but just as a hypothetical, we wouldn't want to ignore depression looking for alcohol.
Right.
Okay. And the other question I had on paragraph 56 was the requirement for written apologies. I don't recall us doing that before, and maybe we have, but I just don't recall. I'm not even sure we can, but it just struck me as odd.
I don't recall the court having done that before, but certainly I couldn't say that the court hasn't. I'm not sure what the answer to that is. I do recall during the panel hearing that there was a question posed, if I'm correct, by one of the panel members asking the respondent if they had apologized to their client. So that was, if my memory serves me correctly, brought up in the context of the hearing, that there was a panel member interested in knowing whether or not an apology had been extended.
Any more questions of council? Thank you, council.
Thank you.
If it may please the court, my name is Greg Lee. I am here on behalf of the respondent. I will speak, and then following my comments, Mr. Meyer will speak. Trey Meyer is an alcoholic. It is sad, but it's true. But most importantly, Trey Meyer recognizes that he is an alcoholic. For the past 2 years, he has been in counseling with Rochelle Walsh, a social worker here in Topeka, and has seen her more than 24 times. In addition, he is coordinating an alcohol treatment program through Ann McDonald at KLAP. The alcohol abuse that is set out in the final hearing report and the lawyer misconduct that is set out in the final hearing report comes on the heels of a very tumultuous 5-year period that started in 2007. At the time, Mr. Meyer was a partner in the law firm of Skepik, Fagan, Meyer and Davis in Lawrence, Kansas. In 2007, his secretary committed suicide. A few months later, his secretary's fiance committed suicide at the secretary's graveside. In mid-2008 and early 2009, it was discovered that approximately $100,000 had left the firm's operating account. And the first 4 months in 2009, the lawyers in the law firm weren't paid. As a result, in October of 2009, Mr. Meyer left the firm and started in private practice in Lawrence. From January 11, 2011 until approximately September 20th, 2012 is when the misconduct set forth in the formal hearing report occurred. Formal hearing in this case occurred on November 15th, 2013. 2 weeks later, Mr. Meyer's wife was diagnosed with cancer. At the time, she was an attorney in private practice in Lawrence and the mother of 3 children, ages 7, 9, and 11. On December 17th, 2013, she has a bilateral mastectomy. A month later, on January 14, 2014, Mr. Meyer receives the final hearing report. 3 months later, on March 25, 2014, his wife has her last surgery related to the cancer. When Mr. Meyer first saw me in November of 2013, his primary concern was with his wife's health and what he could do to economically salvage the problem facing the situation he saw before the formal hearing panel. Fortunately for Mr. Meyer, his wife has returned to private practice in February of 2014, is working full-time, and her prognosis is good. And even though it will be difficult for them to carry forward economically on one income, Mr. Meyer and his wife are up to the task. What we are here today is to renew Mr. Meyer's request that he made at the hearing panel for a public censure as opposed to a 6-month suspension. As the court is aware, Mr. Meyer is not disputing any of the facts contained in the final hearing report. Mr. Meyer has already sent letters of apology to the 2 victims identified in the final hearing report. He remains in treatment with social worker Walsh, and as I mentioned earlier, he will shortly begin an alcohol treatment program here in Topeka. At the final hearing, the disciplinary administrator's office recommended 3 months to 6 months as a suspension. If the court finds a suspension is in order as opposed to a public censure, I would ask the court to suspend Mr. Meyer for 3 months as opposed to 6 months.
Counsel, I have a question.
Sure.
I just want to understand what's being done to address the alcohol issue. You mentioned at the beginning of your remarks that he was in a program with KLAP, and then you mentioned just now he was going to shortly begin a program in Topeka, and I didn't understand whether that was KLAP or some sort of actual treatment by alcohol addiction
He has
professionals.
been in counseling with social worker Walsh
Right.
for the last 2 years, meeting with her approximately once a month, that has addressed alcoholism and depression.
Okay.
He has made contact with Ann McDonald at KLAB,
Okay.
and I understand will be starting a program through KLAB shortly. He is not in that program as we speak.
Okay. And he hasn't had any inpatient addictions treatment. Is the counseling with the social worker? Is it designed to be outpatient alcohol treatment in essence, or is it just
It's addressing
periodic?
alcoholism, family issues, and depression. He was admitted, this is not in the record, but he was admitted to Stormont Vale on October 30th, 2013, and the records reflect he was there for 5 days for an inpatient alcohol treatment assessment.
So that was subsequent to the panel hearing.
That is correct.
Okay, thank you.
Any additional questions? Thank you, Mr. very much, and now Mr. Meyer would like to briefly address the court.
May it please the court. I appreciate the opportunity to address the court directly. When I signed the attorney roles in September of 1999, I must confess this is not how I envisioned or would have planned my first appearance before this court, but it is what it is. I wish I could say that we saved the best attorney for last today, but unfortunately that is not the case, at least today. One of my favorite phrases from the Bible is John 8:31-32. Jesus tells some of his followers, if you truly are my disciples, then you'll know the truth, and the truth will set you free. And I've kind of adopted that as my own personal mantra the last few months. We are coming up on 2 years during this process, so I obviously have had a great deal of time to reflect on what happened in both these cases, and here's some truth, and that is that I just didn't do a good job for these 2 clients. Kierkegaard said that life must be lived forward, but it can only be understood backwards. I wish that I had had the wisdom and insight 2 or 3 or 4 years ago to step back and take stock of what was going on with me and my life and my family, and especially on the heels of the events that Mr. Lee described. And for whatever reason, I didn't have that wisdom or insight. And so now this process is the impetus for that stepping back and taking stock. I also wish that I had had the humility to ask for help. But I believe God is going to teach me a lot about humility over the next few months. 5 years ago, I couldn't fathom picking up the phone and calling KLAB. I just couldn't believe that that would even be possible. Now that I've done it, It's easy, and I'll do it again if I need to, and I'll recommend to people in my shoes to do the same thing if I ever have the opportunity to do so. As a lot of attorneys that have appeared before you, I'm sure I had Judge Bullock for professional responsibility in law school. And one of his catchphrases has always stuck with me, and that is, get competent, get help, or get out. And he always talked about that in the context of a particular legal matter, but I also think it applies more broadly to the practice. I should have got competent, I should have gotten help, or I should have gotten out myself, and I didn't do that. Our system depends on trust, and folks need to be able to trust that a person that has a law license is up to the task. And I understand that it's part of this court's responsibility to make sure that people are able to have that trust and that faith in the system. And when an attorney doesn't do a good job, as I didn't in these two cases, that trust is eroded, not only in me or the particular attorney, but also in the system. There is a silver lining to all of this, even on a dreary, rainy day like today, and that is that, as I mentioned, this has been a very compelling impetus for me to step back and assess what I'm doing, how I can be better, and the challenges that I'm facing. I knew this before, but it's also been reiterated to me what an incredible network of folks I have surrounding me. About 3 weeks ago, I sent a very detailed email to a number of my family, friends, and colleagues all over the state, describing what I was doing and what I was going through and the fact that I would be here today. And the response that I got back was overwhelming. I have a great family. My wife is wonderful. I'm glad she's not here today, because the reason she's not here is because she's working. I hope it doesn't sound presumptuous when I say that I will be back from this. I'm not taking that for granted, but I will be back. I'm guessing that folks in my shoes before this court in this situation probably say lots of similar things to what I'm saying. And talk is cheap at this stage. But I'm going to demonstrate through my actions to this court that I deserve the privilege of getting my law license back if you choose to suspend me. I'm going to learn all I can from this after reflecting on it a lot. It is not representative of me. I'm not going to let it define me. I'm going to learn what I can from it and move on. I am very disappointed and embarrassed that I'm here. Jody and I talk to our boys all the time about being accountable for your actions. And when you make a mistake, stepping up and taking responsibility. And I think it's important that I show them, not just tell them. As far as the treatment, and I may have not given good information to Mr. Lee, I was not actually admitted to Stormont Vail. I did an assessment, an alcohol assessment at Stormont Vail on October the 31st of 2013. And the recommendation flowing from that assessment was that I would benefit from intensive outpatient treatment for alcoholism. Now, in the meantime, with my wife's cancer diagnosis, as we worked through that process, I put my own treatment situation sort of on the back burner. And now that she is on the road to recovery, now that I've appeared here for this hearing, and we're hopefully going to be moving forward, I am going to make that treatment my first priority. I have been working with Ann McDonald and Bryn Rose at KLAP to try to identify a program that fits my particular needs. We have not selected one yet, but that process is ongoing. Ms. Morose has been particularly helpful with that in identifying a number of programs around the country that she thinks would be a good fit for me, most especially programs that address family needs and also the particular mental health demands of lawyers. I'll put it that way. So that process is ongoing, and I hope to have a definitive answer to that here in the next couple weeks.
So let me understand.
Yes, sir.
You've been seeing a social worker an hour a month for about 2 years. You had an assessment, an outpatient assessment at Stormont Vail in October. They recommended intensive alcohol treatment. It's now May, and you're just now getting to that.
Intensive outpatient treatment, that's true. And the primary reason for that was...
No, I understand. Intensive
Okay.
outpatient treatment, which at least our experience with that type of an evaluation is, at least initially, every day for a long period of time, 3-4 hours a day with that intensive outpatient treatment.
That's my
that they're
understanding as well.
recommending. And you haven't started that
No,
in
sir, I
over
haven't.
8 months.
I have not. That's correct.
And when did you get in touch with KLAP?
Let's see. My recollection, it was shortly after I believe it was shortly after my hearing before the panel, which would have been November the 5th of 2013.
Okay. Okay, so I'm a little confused. The assessment at Stormont took place before the hearing?
The week prior to that, yes, ma'am.
Week prior?
Yes,
Okay.
ma'am. October 31st of 13.
Alrighty, I had the dates mixed up in my head. Okay, and then finally, this is obviously a pretty personal question. But,
Okay.
do you have a period of sobriety that matches your time in treatment with a social worker?
No, it certainly hasn't been 2 years. You know, that's something that I continue to learn about and wrestle with. I've also gone to AA meetings from time to time, and so I don't have an extended period of sobriety that I could describe for the court today. I have great weeks and I have a bad day every now and then, and that's what I'm trying to learn about and acquire some tools to deal with.
Okay, thank you.
Could you tell me about the nature of your practice? And I want to know a couple of things. I mean, the cases involved with the discipline were domestic cases.
Yes,
but
sir.
What's been your type of practice?
Right.
And are you and do you practice with anyone?
Right.
Either in office sharing or in partnership or associations?
Right. Historically, my practice mix has been anywhere from a half to 2/3 domestic. And this would be since I left my firm in 2009. That's the period that I'm talking about. Half to 2/3 domestic. I do a little bit of civil litigation, nothing that's terribly involved because I do practice by myself. I do some criminal defense, and ironically, I've done a fair bit of work before the Board of Healing Arts and the Board of Nursing, helping medical professionals who are in circumstances similar to my own here today, which is sort of a niche practice that I've developed the last couple years. I was completely by myself in terms of office arrangements from October of 2009 until the beginning of 2012, at which time I moved into an office sharing arrangement with 3 other lawyers, not partners. We just share office space.
And that's what exists today?
Yes, sir. There are 4 lawyers that share our space. My wife is one of them. So 4 lawyers total. Yes, sir.
Counsel, I did have a question for you.
Yes, sir.
And I'm referring to paragraph 35 of the final hearing report that talks about attorneys must act with reasonable diligence and promptness in representing their clients, see KRPC 1.3. And then the last part of that paragraph says the respondent's lack of diligence caused TG actual injury. She was forced to share a residence with her abusive, estranged husband for an extended period of time. Because the respondent failed to act with reasonable diligence and promptness in representing his client, the hearing panel concludes that he violated KRPC 1.3. Here's my question. You've indicated to us you've already sent letters of apology to these 2 clients.
Yes, sir.
So my question is, what do you tell this woman who the panel said you forced to share a residence with her abusive, estranged husband for an extended period of time? I'm just kind of curious what your letter said.
Well, I told her that I regretted very much that that the way I handled her case caused her to suffer from that situation. I felt like at the panel hearing that it was a little bit more complicated than that because of some of her wishes in terms of what county that we filed the case in and that sort of thing. But and that was kind of a evolving situation from the time that she initially contacted me to the time that it got to the point where that situation had developed. So it wasn't, a lot of cases that I've gotten over the years, right from the very beginning when the client comes in that this is a case where, whether it's because of that kind of situation or whatever else, that we ought to file immediately, go get ex parte temporary orders, remove a person from a home, and that's the course that's appropriate. That wasn't the posture of the case when this woman originally retained me. It was more, hey, we want to just try to get all this worked out. We want to do a settlement agreement by agreement. We basically have the details put together, and as happens from time to time, it just didn't happen that way. But I deeply regret that something that I did or did not do caused her and her children to, be in that situation. I mean, I regret that deeply.
And that was expressed in your letter of apology?
I told her that I regretted that, that I don't remember the exact words, but that I regretted that my situation caused her anxiety or pain or grief. I can't remember the word that I used. Yes, sir.
Thank you. Did you have any further presentation for us?
I have one more item that I'd like to address, if I could. I see that I'm out of time.
This is an important issue. You may proceed.
Thank you, Your Honor. I haven't taken on any new cases since about January, just in anticipation of whatever the court chooses to do. I do have about 3 or 4 cases that are set for final disposition the first part of June. And I would greatly appreciate it if whatever the court does, if it chooses that suspension is appropriate, to not have that begin until about the middle of June so that I could get these cases finished up. I'm prepared to transition those cases to other attorneys, but I'm prepared to carry those through to their final hearing, and I would very much like to do that, both myself and on behalf of my clients. So I don't have anything further unless there are more questions.
Any more questions of counsel? Thank you, counsel.
Thank you.
You reserve 2 minutes for rebuttal.
Thank you, Chief Justice Nuss. 2 points I think I would like to address. My recommendation at the hearing was a 3-month to a 6-month loss of license. At that time, I did not know whether or not the hearing panel would conclude that the evidence supported an 8.4C violation. And given the fact that they found, by clear and convincing evidence, that there was misrepresentation and dishonest conduct, then certainly the recommendation is and should be a 6-month suspension. The respondent testified at the hearing that he had undergone this diagnostic evaluation at Stormont Vale the week before the hearing. Nothing was brought with him from that. He didn't present any information that the panel could look at to see what these doctors concluded as a result of that evaluation. These cases, but particularly the second case, the Tina Roberts divorce, it is fraught with representations of, I put the petition in the mail. I've done that. Let me check on that. In response to her questions about, have you done this yet? Yep, it's done. There was a representation to subsequent counsel. The check's in the mail. The refund check is in the mail. It's coming. There was evidence in the record of a response to the investigator. My answer is coming. It'll be, my response to you will be, you'll get it on the 18th. In this particular case, I would suggest that we must insist in order to protect the public that the respondent produce to the panel evidence, documents that he's actually undergone the treatment and counseling that he has described, and then provide to a panel of the recommendation of someone that can tell us objectively what's going on and what needs to be done. And I would renew our recommendation that you not consider a public censure is appropriate in this case and order a 6-month suspension and a 219 hearing.
Thank you, counsel. Do I have any further questions? I see none. Thank you. Thank you all for your arguments this morning and this afternoon. We'll take this matter under advisement. That concludes